ರೀತಿಯಾಗಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯ ಮಾರ್ಗದೆಡೆಗೆ ನ್ಯಾಯ ವಿತರಣೆಯಲ್ಲಿ ಶಾಸನಬದ್ಧ ನ್ಯಾಯಾಧಿಕರಣಗಳ ಪಾತ್ರ ಈ ವಿಷಯದ ಮೇಲೆ ಇಂದು ಮತ್ತು ನಾಳೆ ಜರುಗಲಿರುವ ಮಹತ್ವದ ಈ ರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದ ಸಂಕೀರ್ಣ ಸಮಾವೇಶಕ್ಕೆ ಮೊದಲನೇದಾಗಿ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದ ಗೌರವಾನ್ವಿತ ಸಿದ್ದರಾಮಯ್ಯರವರಿಗೆ ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧಿಕರಣದ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಕಪಿಲ್ ಮೋಹನ್ ರವರು ಸನ್ಮಾನ್ಯರಿಗೆ ಸ್ವಾಗತಿಸಲು ಕೋರುತ್ತೇನೆ. ಸಂಕೀರ್ಣ ಸಮಾವೇಶಕ್ಕೆ ಆಗಮಿಸಿರುವ ಘನ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಶ್ರೀ ಮೋಹನ್ ಎಂ ಶಾಂತನಗೌಡರ್ ರವರಿಗೂ ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧಿಕರಣದ ಅಧ್ಯಕ್ಷರು ಸನ್ಮಾನ್ಯರಿಗೆ ಸ್ವಾಗತಿಸಲು ಕೋರುತ್ತೇನೆ. ಅದೇ ರೀತಿಯಾಗಿ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶಕ್ಕೆ ಆಗಮಿಸಿರುವ ಕರ್ನಾಟಕ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಶ್ರೀ ಸುಬ್ರೋ ಕಮಲ್ ಮುಖರ್ಜಿ ರವರಿಗೂ ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧಿಕರಣದ ಅಧ್ಯಕ್ಷರು ಸನ್ಮಾನ್ಯರಿಗೆ ಸ್ವಾಗತಿಸಲು ಕೋರುತ್ತೇನೆ. ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸನ್ಮಾನ್ಯ ಕಂದಾಯ ಸಚಿವರಾದ ಶ್ರೀ ಕಾಗೋಡು ತಿಮ್ಮಪ್ಪರವರಿಗೂ ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧಿಕರಣದ ಕಂದಾಯ ಸದಸ್ಯರಾದ ಶ್ರೀ ಕೆ ಹೇಮಾಜಿ ನಾಯಕ್ರವರು ಸನ್ಮಾನ್ಯರಿಗೆ ಸ್ವಾಗತಿಸಲು ಕೋರುತ್ತೇನೆ. ಅದೇ ರೀತಿಯಾಗಿ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶಕ್ಕೆ ಆಗಮಿಸಿರುವ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಶ್ರೀ ಸುಭಾಷ್ ಚಂದ್ರ ಖುಂಟಿಯಾ ರವರಿಗೂ ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧಿಕರಣದ ಅಧ್ಯಕ್ಷರು ಸನ್ಮಾನ್ಯರಿಗೆ ಸ್ವಾಗತಿಸಲು ಕೋರುತ್ತೇನೆ. ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಸಚಿವರಾದ ಶ್ರೀ ಟಿ.ಬಿ. ಜಯಚಂದ್ರ ರವರಿಗೂ ಸಂಕೀರ್ಣ ಸಮಾವೇಶದ ವಿಷಯ ತಜ್ಞರು ಶ್ರೀ ಸುಧೀರ್ ಕೃಷ್ಣಸ್ವಾಮಿರವರು ಅಜೀಂ ಪ್ರೇಮ್ಜಿ ವಿಶ್ವವಿದ್ಯಾಲಯರವರು ಸನ್ಮಾನ್ಯರಿಗೆ ಸ್ವಾಗತಿಸಲು ಕೋರುತ್ತೇನೆ. ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶಕ್ಕೆ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಉನ್ನತ ಅಧಿಕಾರಿಗಳು ಸೇರಿದಂತೆ ಬೇರೆ ಬೇರೆ ರಾಜ್ಯಗಳಿಂದ ಆಗಮಿಸಿರುವ ಎಲ್ಲ ವಿಷಯ ತಜ್ಞರಿಗೆ ಹಾಗೂ ಸಮಾವೇಶದಲ್ಲಿ ಭಾಗವಹಿಸಿರುವ ಎಲ್ಲ ಅತಿಥಿ ಅಧಿಕಾರಿಗಳಿಗೆ ಹಾಗೂ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶದಲ್ಲಿ ಭಾಗವಹಿಸಿರುವ ಸಹೋದ್ಯೋಗಿ ಮಿತ್ರರಿಗೆ ಹಾಗೂ ಪತ್ರಿಕಾ ಮಿತ್ರರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾದ ಸ್ವಾಗತವನ್ನು ಕೋರುತ್ತೇನೆ. ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶವು ಸರ್ವ ರೀತಿಯಲ್ಲೂ ಯಶಸ್ವಿಯಾಗಲೆಂದು ಆ ಸರ್ವಶಕ್ತನಾದ ಭಗವಂತನಲ್ಲಿ ಭಕ್ತಿಯಿಂದ ಪ್ರಾರ್ಥಿಸಲು ಶ್ರೀಮತಿ ಸಾವಿತ್ರಮ್ಮರವರಿಗೆ ವೇದಿಕೆಯಲ್ಲಿ ಆಗಮಿಸುವಂತೆ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಕೋರುತ್ತೇನೆ.
सदा विमुक्तिसाधकं कलाधरावतंशकं विलासिलोकरक्षकं मुदाकरातमोदकं सदा विमुक्तिसाधकं कलाधरावतंशकं विलासिलोकरक्षकं अनायकैकनायकं विनाशिते भदैत्यकं नताशुभाशुनाशकं नमामि तं विनायकं नमामि तं विनायकम् अकिञ्चनार्तिमार्जनं चिरन्तनोक्तिभाजनं पुरारिपूर्वनन्दनं सुरारिगर्वचर्वणं प्रपञ्चनाशभीषणं धनञ्जयामि भूषणं कपोलदानवारणं भजे पुराणवारणं भजे पुराणवारणम् अतान्तकान्तिदन्तकान्तिमन्तकात्मकात्मजम् अचिन्त्यरूपमन्तहीनमन्तरानकन्तरं हृदन्तरे निरन्तरं वसन्तमेव योगिनां त्वमेकदं तमेव तं विचिन्तयामि सन्ततम्. Thank you. Thank you.
ಇದುವರೆಗೆ ಭಕ್ತಿಪೂರ್ವಕವಾಗಿ ಪ್ರಾರ್ಥನೆಯನ್ನು ಸಲ್ಲಿಸಿದ ಶ್ರೀಮತಿ ಸಾವಿತ್ರಮ್ಮ ಹಾಗೂ ಪುತ್ರಿಗೆ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸುತ್ತಾ ಈಗ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ದೀಪವನ್ನು ಬೆಳಗಿಸುವುದರ ಮೂಲಕ ಸಮ್ಮೇಳನವನ್ನು ಉದ್ಘಾಟಿಸುವಂತೆ ಕೋರುತ್ತೇನೆ ಹಾಗೂ ವೇದಿಕೆಯಲ್ಲಿ ಹಾಜರಿರುವ ಎಲ್ಲ ಗಣ್ಯ ವ್ಯಕ್ತಿಗಳಿಗೆ ಉದ್ಘಾಟನೆಯಲ್ಲಿ ಭಾಗವಹಿಸಲು ಕೋರುತ್ತೇನೆ.
ಷಣ್ಮುಖಾಗ್ರಜನೆ ಸಲಹೋ ನಿನ್ನ ಭಕ್ತರನ್ನು, ಷಣ್ಮುಖಾಗ್ರಜನೆ ಸಲಹೋ ನಿನ್ನ ಭಕ್ತರನ್ನು, ಸಾಷ್ಟಾಂಗ ಪ್ರಣಾಮವನು ಮಾಡೋ ದಾಸರನ್ನು, ಸಾಷ್ಟಾಂಗ ಪ್ರಣಾಮವನು ಮಾಡೋ ದಾಸರನ್ನು, ಷಣ್ಮುಖಾಗ್ರಜನೆ ಸಲಹೋ ನಿನ್ನ ಭಕ್ತರನ್ನು. ಪ್ರದಕ್ಷಿಣೆಗಳಿಂದ ಗೆದ್ದೆ ನಿನ್ನ ತಮ್ಮನನ್ನು ಯಾರು ತಿಳಿವರಯ್ಯ ನಿನ್ನ.
ಜ್ಯೋತಿಯನ್ನು ಬೆಳಗಿಸಿ ಸಮ್ಮೇಳನವನ್ನು ಉದ್ಘಾಟಿಸಿರುವ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಹಾಗೂ ಅನ್ಯ ಗಣ್ಯ ವ್ಯಕ್ತಿಗಳಿಗೆ ಅತಿಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸುತ್ತೇನೆ. ಈಗ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಸಂಕೀರ್ಣ ಸಮಾವೇಶದ ಉದ್ಘಾಟನಾ ಭಾಷಣವನ್ನು ನೀಡಬೇಕೆಂದು ಕೋರುತ್ತೇನೆ.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಜಸ್ಟಿಸ್ ಶ್ರೀ Mohan M. Shantanagoudar, Hon'ble Judge, Supreme Court of India, Sri Subhro Kamal Mukherjee ji, Honorable Chief Justice of Karnataka High Court, Sri Kagodu Thimmappa, Honorable Minister for Revenue, Sri T.B. Jayachandra, Honorable Minister for Land, Parliamentary Affairs and Minor Irrigation, Sri Subhash Khuntia, Chief Secretary, Government of Karnataka, distinguished invitees, media friends, ladies and gentlemen. I am indeed delighted to inaugurate this national conference convened to discuss one of the most important themes of the present day, reforms in the working of quasi-judicial bodies. Today's National Conference is one of the most exceptional occasions when representatives of all the three organs of the state, the legislative, the executive, and the judiciary, have come together to focus their collective wisdom on the topic. As we are all aware, the doctrine of separation of powers envisages a tripartite system in which powers are delegated to the three organs distinctly and separately. This doctrine is being considered as one of the basic features of our Constitution, with the concept of separation of judiciary from the executive being incorporated in the Directive Principles under Article 50. We have now come to accept the fact that the principle of separation of powers cannot be strictly applied in any modern government. Suffice to say that each organ of the state should exercise its powers on the principle of checks and balances, signifying the fact that none of the organs shall usurp the essential functions of the other. The word quasi means not exactly. Thus, an authority is described as quasi-judicial when it has some attributes of judicial functions, but not all. Quasi-judicial function is an action by an administrative agency which ascertains certain facts, holds hearing, weighs evidence, makes conclusions from the facts as a basis for the official actions, and exercises discretion of a judicial nature. When the executive or the administrative performs the judicial functions, it is yet to act as a quasi-judicial authority. Few examples could be National Human Rights Commission, State Human Rights Commission, Information Commissions, various tribunals, commissions of inquiry, ombudsman in various organizations. With this undertaking as the backdrop, we will be better equipped to appreciate the significance of the topic of this national conference. During my brief stint in the legal profession, I had some insights into the working of quasi-judicial bodies, based on which I would like to suggest few gray areas upon which all of you can brainstorm the topic so that reforms are brought about at various levels. Access to justice being the lofty ideal pursued by the quasi-judicial bodies, reforms can begin with their very constitution, composition, and methodologies adopted by them to redress the grievances in an expeditious and inexpensive manner without sacrificing the quality of the orders. I exhort upon all of you to check out a detailed set of guidelines which could be followed by the quasi-judicial authorities across the country. While finalizing these guidelines, best practices followed by certain quasi-judicial bodies ought to be incorporated. As an example for emulation, I would like to mention the case watch system adopted by the Karnataka Appellate Tribunal, for which our government has provided financial assistance of rupees 9.74 crore. This unique software helps the general public and advocates to file their cases online and track the cases till their disposal. For the expeditious disposal of cases, the proposal for establishing 2 more benches and genuine demand of an exclusive building for the Karnataka Appellate Tribunal are under the active consideration of our government. Friends, it is high time that activism is infused in the quasi-judicial bodies, similar to the judicial activism prevalent in the courts. May this national conference be the harbinger of change in the destiny of quasi-judicial bodies. I wish this national conference all success. Thank you all. Jai Hind, Jai Karnataka.
I thank the Honorable Chief Minister for sharing his valuable thoughts on access to justice, and I thank him for promising us to give land for the KT office. ಈಗ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಧಾನ ಭಾಷಣಕಾರರಾದ ಕರ್ನಾಟಕ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಶ್ರೀ ಸುಬ್ರೋ ಕಮಲ್ ಮುಖರ್ಜಿರವರು ಈ ಸಮ್ಮೇಳನದಲ್ಲಿ ಪ್ರಮುಖ ವಿಷಯಗಳ ಮೇಲೆ ಭಾಷಣ ನೀಡುವಂತೆ ಕೋರುತ್ತೇನೆ.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Those who have come from outside, it being a national conference, I have to translate it. Namaskar to you all. Honorable Mr. Justice Mohan M. Shantanagoudar, the Honorable Judge, Supreme Court of India, my esteemed brother and sister judges, Sri Siddaramaiah, the Honorable Chief Minister, Government of Karnataka, Mr. T.B. Jayachandra, Honorable Minister for Law, Parliamentary Affairs, Minor Irrigation, Government of Karnataka, Mr. Kagodu, Thimmappa, Honorable Revenue Minister, Government of Karnataka, Mr. Subhash Chandra Khuntia, the Chief Secretary, Government of Karnataka, Mr. Kapil, Mohan, Chairman, Karnataka Appellate Tribunal, and his members, Chairperson, and the members of various tribunals and the appellate tribunals, landed members of the bar, officers of the Government of Karnataka, distinguished guests, ladies and gentlemen, members of the media and electronic media. Good morning, everybody. At the outset, I must thank the chairman, Mr. Kapil Mohan, Karnataka Appellate Tribunal, and the organizers for having invited me to participate in the two-day national conference on the reforms in working of quasi-judicial bodies at Bengaluru. A radical change was brought about in the constitutional law by way of 42nd Amendment. Amendment was very controversial, and a lot of the amendments were to be scrapped by way of 44th Amendment, but the insertions of Articles 323A capital A and 323 capital B was inserted by the 42nd Amendment and is retained till today. Knowing fully well about the judge litigation proportion in this court, in this country, which is very poor in comparison to any other developed countries or quasi-developed countries. The conception of establishment of administrative tribunals were thought of. The administrative tribunals were thought of because in some specialized matters, it required specialized involvement. In general sense, the tribunals are not courts of normal jurisdiction, but they have very specific and limited jurisdiction. They were established in all democratic countries in the world. The statement of object and the reasons accompanying the constitutional amendment bill by which Articles 323 capital A and 323 capital B were sought to be inserted in the Constitution was to set up the tribunals to reduce the workload of the courts, to expedite decisions, and to provide a forum which would consist of both law-knowing persons and experts in the field, falling within the jurisdiction of the tribunal. The 42nd Amendment of 1976 brought about a massive change in the adjudication of disputes in the country as provided in those enactments. The Parliament provides for establishment of tribunals to adjudicate on the matters specified in the subclauses with regard to which the respective legislatures had the powers to make rules. That is 323 capital A, power vested with the central government, 323 capital B, power vested with the state government. The 323 capital A was to be effective only if the Parliament implemented a law in this regard and the Administrative Tribunal Act 1985 was enacted. And there are also various other appellate tribunals at the central level, and Income Tax Appellate Tribunal, Debt Recovery Tribunal, Custom and Excise Service Tribunal, Compensations Tribunal, Competition Tribunal, and so on. Now, the most important amendment that was brought to by the 42nd Amendment, even prior to the date of the enactment of the Constitution, as Article 136 provided for the term of tribunal, and further there were tribunals established under the Industrial Disputes Act 1947 and under the Life Insurance Corporation Act 1956. Therefore, it is not that by the 42nd Amendment for the first time tribunals were introduced. There were other tribunals, of course, functioning within their limited jurisdiction. In our Constitution, the expression tribunal has not been defined. But the related legislations, we have some indications, and finally in the decision of the Supreme Court of India, in the case of Durga Shankar Mehta, reported in EIR 1954, Supreme Court 520. I quote, "The expression tribunal as used in Article 136 does not mean the same thing as court, but includes within its ambit all adjudicating bodies, provided they are constituted by the state and are invested with the judicial as distinguished from the administrative or executive functions." What is good for these tribunals, they are not to follow any uniform procedure. They are entitled to develop their own procedures, keeping in view the principles of natural justice and fair play. The present day situation, the tribunals are overcrowded. It shows that the tribunals, the system of introduction of the tribunal is successful. They are not judiciary in true sense of term, but yet they seek to achieve the same objective as that of the courts, that is to deliver justice. That apart, even the tribunals play a very important role in dispensation of speedy justice. The tribunals have been increasing in numbers, and after the insertion of Articles 323 capital A and 323 capital B, numbers of tribunals have gone up. A quasi-judicial body is an entity such as an arbitrator or tribunal board, generally of a public administrative agency which has powers and procedures resembling those of a court of law or judge, and which is obliged to objectively determine facts and draw conclusions from them so as to provide the basis of an official action. Such actions are able to remedy a situation or impose legal penalties and may affect the legal rights, duties, and privileges of specified parties. Ladies and gentlemen, within the four walls of judicial review, tribunals carry a great responsibility of not only resolving dispute, but also exhibiting higher standards of performance, as mostly the tribunals have been reviewing or overseeing appeals from the actions of the administration. The effectiveness of the tribunals can be gauged, and in fact, the very objective of setting up the tribunals can be said to be fulfilled only when the tribunals come up to the expectations of the stakeholders. And if the litmus test in that whether the institution is maintaining consistency of it being fair and judicious, apart from rendering speedy justice, I think tribunals have passed with distinction. Working of an institution depends upon the reputation which it builds upon over a period of time and lived up to the expectation of the litigating public. I am sure the technical sessions in these 2 days will be enlightening and extremely helpful to participants and deliberations, and will be able to stimulate the thought process in your minds. I am looking for a new and innovative ideas out of your stimulated and ignite minds. With these words, I wish all the best on this occasion. I am confident that the deliberations will certainly address the issues concerning the academic and policy gaps which focused attention on the role of tribunals and the appellate tribunals, in pursuing the rule of law and providing affordable and quick access to justice to litigants across India, and shall continue to serve nation and the people of this great country as an instrument of government in much better way. Before I stop, I point out little aberrations. Please pardon me. The reason is there are tribunals constituted. Kindly introspect how many tribunals are full. Most of the tribunals are running with half strength. Appointments are delayed. Here, an appointment was recommended a couple of months back. I was a member of the recommending committee. The former Chief Secretary, Mr. Jadhav, is there. He may be remembering. But till then, the appointment has not come. Once the selection is made, and unless the selection is rejected for some reasons to be recorded, these selections must come as quickly as possible. Otherwise, what happens? People loses interest when they go back court, knowing that the court is not there, therefore the adjournment is as a matter of course. I call upon the administration to look into the matter seriously. I thank you all for your patient hearing and giving me an opportunity to speak on this occasion. I wish the conference a grand success. Illeregu namaskaraಗಳು. Thank you to everybody.
ಕರ್ನಾಟಕ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಶ್ರೀ ಸುಬ್ರೋ ಕಮಲ್ ಮುಖರ್ಜಿರವರಿಗೆ ಧನ್ಯವಾದಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ. ಈಗ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶದ ಕುರಿತು ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಕಂದಾಯ ಸಚಿವರಾದ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ಕಾಗೋಡು ತಿಮ್ಮಪ್ಪರವರು ಈ ಸಮ್ಮೇಳನದಲ್ಲಿ ಭಾಷಣ ನೀಡುವಂತೆ ಕೋರುತ್ತೇನೆ. ಅಧ್ಯಕ್ಷ ಭಾಷಣ ಅಧ್ಯಕ್ಷ
ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದಂಥ ಸಿದ್ದರಾಮಯ್ಯನವರೇ, ನನ್ನ ಪ್ರಿಯರು, ಭಾರತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಆದಂಥ ಶ್ರೀ ಮೋಹನ್ ಶಂತನಗೌಡರವರೇ, ಗೆಳೆಯರು ಮತ್ತು ಕಾನೂನು ಸಚಿವರಾದಂಥ ಜಯಚಂದ್ರರವರೇ, ನಮ್ಮ ಕರ್ನಾಟಕದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂಥ ಶ್ರೀ ಸುಬೋಧ್ ಕಮಲ್ ಮುಖರ್ಜಿ ಅವರೇ, ನಮ್ಮ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳಾದಂಥ ಸುಭಾಷ್ ಚಂದ್ರ ಖಂಟಿಯವರೇ, ನೆರೆದಂಥ ಎಲ್ಲ ನ್ಯಾಯಮೂರ್ತಿಗಳೇ, ನನಗೆ ತುಂಬ ಸಂತೋಷ ಆಗಿದೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ನಿಮ್ಮ ಸಲಹೆಗಳನ್ನು ಕೇಳೋದಕ್ಕೆ. ಆದ್ದರಿಂದ ನಾನು ಏನೂ ಹೇಳೋದಕ್ಕೆ ಬಯಸೋದಿಲ್ಲ. ಒಂದೇ ಒಂದು ನನ್ನ ಪ್ರಾರ್ಥನೆ ಏನಂದರೆ, ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಫ್ರೇಮ್ವರ್ಕ್ನಲ್ಲಿ ಇರುವಂಥ ಶಾಸಕಾಂಗ, ನ್ಯಾಯಾಂಗ, ಕಾರ್ಯಾಂಗ ಇವಿದೆಯವಲ್ಲ, ದೇ ಶುಡ್ ಫಂಕ್ಷನ್ ವಿತಿನ್ ದೇರ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್. ನಮ್ಮ ಪ್ರಜಾತಂತ್ರ ವ್ಯವಸ್ಥೆ ಯಶಸ್ವಿ ಆಗಿದೆ ಇಲ್ಲಿವರೆಗೆ, ಮುಂದೂ ಹಾಗೆ ಉಳಿಬೇಕಂದ್ರೆ ಅವುಗಳು ಅವರವರ ವಿತಿನ್ ದೇರ್ ಫ್ರೇಮ್ವರ್ಕ್ ದೇ ಹ್ಯಾವ್ ಟು ಫಂಕ್ಷನ್ ಮೋರ್ ಎಫೆಕ್ಟಿವ್ಲಿ. ಈ ಕ್ವಾಸಿ ಜುಡಿಷಿಯಲ್ ಬಾಡಿ ಇವತ್ತೇನಿದೆಯಲ್ಲ, ಇದು ಅಗತ್ಯ ನಮ್ಮ ಇವತ್ತಿನ ವ್ಯವಸ್ಥೆಗೆ. ಇದರಲ್ಲಿ ಏನೇನು ಬದಲಾವಣೆ ಆಗಬೇಕು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ತಾವು ಸಲಹೆ ಮತ್ತು ಸೂಚನೆಯನ್ನು ಕೊಟ್ಟರೆ ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ ಸರ್ಕಾರಗಳು ಬದಲಾವಣೆಯನ್ನು ತರ್ತವೆ, ಅಗತ್ಯ ಇದೆ. One should remember we are all in the age of 21st age of science and technology. Age of change also. This century brings about a new change. ಆದ್ದರಿಂದ ಅದಕ್ಕೆ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಆಗೋ ರೀತಿಯಲ್ಲಿ ತಾವು ಸಲಹೆ ಸೂಚನೆ ಕೊಡಬೇಕಾದಂಥ ಅನಿವಾರ್ಯತೆ ಇದೆ. ಅದನ್ನು ನಮ್ಮ ಮುಖ್ಯ ನ್ಯಾಯಾಧೀಶರು ಈಗಾಗಲೇ ಸೂಚನೆ ನೀಡಿದ್ದಾರೆ. ಕ್ವಾಸಿ ಜುಡಿಷಿಯಲ್ ಬಾಡಿ ಹೇಗೆ ಇರಬೇಕು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಐ ಆಮ್ ಸೋ ಗ್ರೇಟ್ಫುಲ್ ಟು ಯು ಸರ್. ಪೀಪಲ್ ಲೈಕ್ ಯು ಶುಡ್ advise the government how to function in the field of quasi judicial bodies. ನಮ್ಮ ಶಾಂತನಗೌಡರು ಹಿರಿಯರಿದ್ದಾರೆ, ಅವರಿಂದಲೂ ನಾವು ಅಪೇಕ್ಷೆ ಪಡ್ತೇವೆ. ಇಷ್ಟು ಮಾತನ್ನು ಹೇಳಿ ನನಗಿಷ್ಟೇ, ಐ ಆಮ್ ಸೋ ಹ್ಯಾಪಿ. ಈ ಒಂದು ಯಾಕಂದರೆ ಇದರಲ್ಲಿ ನಾವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡೋದ್ರಲ್ಲಿ ಏನೋ ಅರ್ಥ ಇರಲ್ಲ, ನಾವೊಬ್ಬ ಸಾಮಾನ್ಯ ಮನುಷ್ಯ. ಆದರೆ ನಿಮ್ಮಿಂದ ನಾವು ನಿರೀಕ್ಷೆ ಕೇಳ್ತೀವಿ, ಹೊಸ ಬದಲಾವಣೆಗೆ ಏನು ಸಲಹೆ ಕೊಡ್ತೀರಿ. ದಟ್ ಇಸ್ ಆಲ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್. Thank you very much.
ನ್ಯಾಯಾಧೀಕರಣದ ವಿಷಯಗಳ ಕುರಿತು ತಮ್ಮ ಭಾಷಣವನ್ನು ನೀಡಿದ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಕಂದಾಯ ಸಚಿವರಿಗೆ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ಈಗ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶದ ಕುರಿತು ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಸಚಿವರಾದ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ಟಿ.ಬಿ. ಜಯಚಂದ್ರರವರು ಈ ಸಮ್ಮೇಳನದಲ್ಲಿ ಭಾಷಣ ನೀಡುವಂತೆ ಕೋರುತ್ತೇನೆ.
ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧೀಕರಣದ ವತಿಯಿಂದ ರಾಷ್ಟ್ರ ಮಟ್ಟದ ವಿಚಾರಣಾ ಸಂಕೀರ್ಣದ ಸಮಾವೇಶವನ್ನು ಉದ್ಘಾಟಿಸಿದಂಥ ರಾಜ್ಯದ ಮುಖ್ಯಮಂತ್ರಿಗಳಾಗಿರ್ತಕ್ಕಂಥ ಸಿದ್ದರಾಮಯ್ಯನವರೇ ಮತ್ತು ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಪ್ರಧಾನ ಭಾಷಣಕಾರರಾಗಿ ಬಂದಿರತಕ್ಕಂಥ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾಗಿರ್ತಕ್ಕಂಥ ಸುಭ್ರೋ ಕಮಲ್ ಮುಖರ್ಜಿರವರೇ, ನಮ್ಮವರೇ ಕರ್ನಾಟಕದವರೇ ಆಗಿರ್ತಕ್ಕಂಥ ಭಾರತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾಗಿರ್ತಕ್ಕಂಥ ಮೋಹನ್ ಶಂತನಗೌಡರವರೇ, ಹಿರಿಯರು ಮತ್ತು ವಕೀಲರಾಗಿರ್ತಕ್ಕಂಥ ಕಾಗೋಡು ತಿಮ್ಮಪ್ಪನವರೇ, ಸುಭಾಷ್ ಖುಂಟಿಯಾರವರೇ ಮತ್ತು ದೇಶದ ಬೇರೆ ಬೇರೆ ಭಾಗದಿಂದ ಬಂದಿರತಕ್ಕಂಥ ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ಆಹ್ವಾನಿತರೇ ಮತ್ತು ನ್ಯಾಯಾಧೀಶರೇ, ನನ್ನ ಸಹೋದರರೇ, ನನ್ನ ಸ್ನೇಹಿತರೆ, ಬಹುಶಃ ನಾನು ಬೇರೆ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಹೋಗಬೇಕಾಗಿದ್ದರಿಂದ ನಾನು ಹೆಚ್ಚು ಮಾತಾಡ್ತಕ್ಕಂಥ ಸಂದರ್ಭ ಇಲ್ಲ. ಹಾಗಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಶುಭಾಶಯಗಳನ್ನು ಹೇಳ್ತಾ, ನಾನು ಬಹುಶಃ ಇಲ್ಲಿ ಕ್ವಾಸಿ ಜುಡಿಷಿಯಲ್ ಅಥಾರಿಟೀಸ್ ಯಾವುದೇ ರಾಜ್ಯಕ್ಕೆ ಹೋದರೂ ಕೂಡ ಒಂದು ರೀತಿಯಾದ ಸಮಸ್ಯೆಗಳಿರ್ತದೆ. ಬಹುತೇಕ ಸಮಸ್ಯೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮೂಲಭೂತವಾಗಿರ್ತಕ್ಕಂಥ ಸಮಸ್ಯೆಗಳು. ಅವ್ರಿಗೆ ಸ್ವತಂತ್ರವಾಗಿರ್ತಕ್ಕಂಥ ಕಟ್ಟಡಗಳಿರಲ್ಲ, ಅವರು ಬೇಕಾದಂಥ ಸ್ಟಾಫು ಸಿಗೋದಿಲ್ಲ. ಇದು ಎಲ್ಲ ಒಂದು ಕಡೆಗೆ ಕೇಸಸ್ಗಳು ಕೂಡ ಸರಿಯಾಗಿ ಸಮರ್ಪಕವಾಗಿ ವಿಲೇವಾರಿ ಆಗ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು ಅದು ಕಾನೂನಿನ ದೃಷ್ಟಿಯಿಂದ ಒಳ್ಳೆಯದು ಅಲ್ಲ. ಹಾಗಾಗಿ ಈಗಾಗಲೇ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಪ್ರಧಾನ ಭಾಷಣ ಮಾಡುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಆಶ್ವಾಸನೆ ನೀಡಿದ್ದಾರೆ, ಸ್ವತಂತ್ರವಾದಂಥ ಕಟ್ಟಡವನ್ನು ಕೊಡಬೇಕು ಅಂತಕ್ಕಂಥ ಮಾತನ್ನು ಕೂಡ ಹೇಳಿದ್ದಾರೆ ಮತ್ತು ಅದಕ್ಕೆ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥ ಹುದ್ದೆಗಳನ್ನು ಕೂಡ ಕೊಡ್ತಕ್ಕೆ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನು ಹೇಳಿರ್ತಕ್ಕಂಥದ್ದು. ಮತ್ತು ನಾನಾದರೂ ಕೂಡ ಇಷ್ಟೇ ಹೇಳ್ತಕ್ಕಂಥದ್ದು, ಇದಕ್ಕೆ ಈ ರಾಷ್ಟ್ರಮಟ್ಟದ ಸಂಕೀರ್ಣಕ್ಕೆ ಯಶಸ್ಸನ್ನು ಕೋರಿ ಮತ್ತು ಇಲ್ಲಿ ಮೂಡಿ ಬರ್ತಕ್ಕಂಥ ಅಭಿಪ್ರಾಯಗಳಿಗೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಯಾವತ್ತು ಮನ್ನಣೆ ಕೊಡ್ತದೆ. ನಾನು ಕಾನೂನು ಸಚಿವರಾಗಿ ಅದನ್ನು ಹಿಂಬಾಲಿಸಿ ಅದನ್ನು ಅನುಷ್ಠಾನ ಮಾಡಿಸ್ತಕ್ಕಂಥ ಜವಾಬ್ದಾರಿಕೆ ನಂದಿದೆ. ಅದು ಅತ್ಯಂತ ಪ್ರಾಮಾಣಿಕವಾಗಿ ಮಾಡ್ತೇನೆ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನು ಹೇಳಿ ನಾನು ಮಾತನ್ನು ಮುಗಿಸ್ತೇನೆ. ನಮಸ್ಕಾರ.
ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಸಚಿವರಾದ ಶ್ರೀ ಟಿ.ಬಿ. ಜಯಚಂದ್ರರವರಿಗೆ ಧನ್ಯವಾದಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ. ಈಗ ಈ ಸಂಕೀರ್ಣ ಸಮಾವೇಶದ ಕುರಿತು ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳು ಶ್ರೀ ಸುಭಾಷ್ ಚಂದ್ರ ಖುಂಟಿಯಾರವರು ಈ ಸಮ್ಮೇಳನದಲ್ಲಿ ಭಾಷಣ ನೀಡುವಂತೆ ಕೋರುತ್ತೇನೆ.
Esteemed Judge of the Supreme Court, Justice Mohan Shantanagoudar, esteemed Chief Justice of the High Court of Karnataka, Justice Subhro Kamal Mukherjee, Honorable Minister of Revenue, Sri Kagodu Thimmappa, the Honorable Judges of the High Court, members of the Bar, Chairmen and members of tribunals of various states, including Karnataka, former Chairman of Karnataka Appellate Tribunal, and invitees and friends. It's really a unique occasion today that chairmen and members of various tribunals from various states of the country are together, and I think this is, there have not been many instances of interchange of views among different tribunals from various states. Different states have different structures. For example, in Karnataka we have a appellate tribunal which deals with revenue cases, cases involving cooperative act and also commercial tax. There are in other states there are tribunals, separate tribunals for to deal with cooperation, separate tribunals to deal with commercial tax. So I think this is a good occasion for interchange of views as to what could be good structures of tribunals in the country. As all of you know that tribunals being quasi-judicial bodies, they are not judicial, they are more administrative in nature, but at the same time, they also follow judicial principles to a great extent. So there are members, judicial members as well as administrative members. The administrative members come from the department, and they are they use the expertise and domain knowledge of the department in deciding cases. At the same time, the judicial members impart kind of judicial discipline while hearing the cases. So this is a kind of good combination of judicial mind and the administrative acumen. The functioning of tribunals, I think they need to be reviewed in great detail. I was, of course, pleasantly surprised to see that in Karnataka Appellate Tribunal for the last 3 years, the disposal is almost twice the receipt, which is a good sign that more of arrears are being cleared off. But tribunals are facing several problems. One is, of course, about staffing. There are large number of vacancies which need to be filled up. So this is something, I am not talking of only Karnataka Appellate Tribunal, but there are many tribunals at various levels. So this is one burning issue. The second one is about the working of the tribunal and other administrative assistance that they need and the way they function. So I think this should be a good occasion for
detailed deliberation on what could be done, because the people who are working in the tribunal, I think they would be in the best position to discuss about these issues and come out with a kind of blueprint as to how to reform the tribunal system in the country. So I wish the deliberations all success, and as far as the state of Karnataka is concerned, I would like to give an assurance that whatever administrative setup support is required from the state government, we would like to give to strengthen our tribunals and to make them to do better. I think with the use of now the technology and particularly ICT, lot of things can be simplified and they can be monitored better, and I think Karnataka Appellate Tribunal is already putting in place a kind of IT-based system. I would like to congratulate the chairman, Sri Kapil Mohan, for starting this initiative, and I hope this initiative will be something that can be emulated by many other tribunals to ensure speedier justice and less expensive, which will be less expensive to the clients. Thank you very much.
I thank the Chief Secretary, Sri Subhash Chandra Khuntia, for giving us his valuable thoughts. Now I invite Honorable Justice Sri Mohan Shantanagoudar, Judge Supreme Court of India, to give share his thoughts on the subject.
Honorable Chief Minister in his absentia, Sri Siddaramaiah ji, Honorable Chief Justice Sri Subhro Kamal Mukherjee, Honorable Law Minister, Revenue Minister Sri Kagodu Thimmappa ji, Law Minister Jayachandra ji, Chief Secretary Khuntia, brother and sister judges, Sri Kapil Mohan, Chairman Karnataka Appellate Tribunal, learned advocates, learned senior advocates, learned advocates, delegates, and other dignitaries and friends. I am from a rural place. In our area, the elders talk that you should not be born as the first child in the family, because the first child will have more responsibility as it grows. And we should not be the last speaker in the conference, because everybody would be leaving me before Chief Justice leaves the place, maybe because of my friendship him. I thank the organizers, particularly the chairman of Karnataka Appellate Tribunal, Bangalore, for having invited me to attend the program. This national conference provides an opportunity for the members serving in different quasi-judicial bodies to learn from each other's practical experience. I find that the legal luminaries, legal practitioners and tribunal members are attending this prestigious conference from this state as well as from the entire nation to share their thoughts for improving the functioning of the tribunals. Though at an earlier point of time, concerns about the efficiency of the tribunals were raised, the statements indicate that most of the tribunals have performed well in recent years. Apart from this critical viewpoint, there have also been arguments made against the policy choice of creating specialist tribunals such as service tribunals at the first instance. For example, the report of Arrears Committee headed by Sri V.S. Manimat submitted its report in 1990, expressed skepticism about the efficiency of the tribunals and instead suggested an expansion of high courts with benches specializing in different areas of substantive law. At an academic level, Several arguments can be made against the increasing tribunalization of justice, but, however, keeping in practical consideration in mind, there are also some compelling reasons for continuing with them. As we all know that the Constitution Bench of the Supreme Court, in the case of L. Chandrakumar, 1997, Part 3, SCC 261, has held that the orders of the tribunal constituted under Article 323A and B are subject to scrutiny of High Courts under Article 226 and 227 of the Constitution, which prescribe the powers of superintendents over subordinate courts and tribunals. Thus, the genesis of the tribunals can be traced as in the aforementioned two articles, the objective of which was to create tribunals which would reduce the burden on the High Courts and the Supreme Court of India and dispose disputes with efficacy. The articles empower the appropriate legislature of the state and central government to establish tribunals for the purpose of trying and adjudicating disputes, complaints, and offences with respect to all or any of the matters specified relating to, among others, levy, assessment, etc., etc. The concept is to create a unique system to face challenge to the efficient administration of justice, with more developed and growing infrastructure, issues involving complicated questions, adjudication of rights vis-a-vis issues of development require specialized knowledge and expertise which are not available with regular courts. The specialized tribunals with appropriate qualified members are therefore able to dispose of matters with adeptness. The members of the tribunal generally are the persons who are or have been or are qualified to be judges of the Supreme Court or the High Court or the district courts, and the persons of ability, integrity, and standing who have special knowledge of and professional experience in science, technology, economics, banking, law, etc. Their special knowledge or professional experience would be useful to the quasi-judicial bodies. Dear friends, it is to be remembered that when a civil consequence ensue, there is hardly any distinction between the administrative order or quasi-judicial order. There might have been difference of opinion at one point of time, but it is now well settled that the thin demarcation or thin demarcated line between an administrative order and quasi-judicial order now stands obliterated. 1969 Part 2 SCC, there are so many judgments, 2007 Part 2 SCC and 1981 Supreme Court 136. I say so because even while taking certain administrative decisions, more particularly deciding lists between the parties, the Tahsildar, Assistant Commissioner or the Deputy Commissioner need to apply their mind and issue notice to both the parties, hear both the parties, then pass orders, reasonable orders. Almost the very work is done by the quasi-judicial bodies. So also, quasi-judicial bodies have got the same trapping of, some trapping of the civil court, judicial courts. Since the orders of the of course, the strict principles of CPC, Evidence Act, and other enactment may not apply to quasi-judicial authorities, but some trappings of courts are available for the quasi-judicial authorities. Since the orders of the quasi-judicial authorities are subject to superintendent of High Court, it is incumbent on the part of the quasi-judicial bodies to pass orders which must meet the test of reasonableness, particularly when, by reason of such order, the citizen of India would be visited with civil or evil consequences. Even when the statute is silent on the question as to whether the person should be heard or not, it is the duty of the quasi-judicial body to hear the person before it, before passing the order, inasmuch as such person has got right to be heard. The judgments earlier rendered by the Supreme Court show that your order may be quasi-judicial order, the authorities of these tribunals may be cryptic, they need not give reasoned orders, etc., etc. That's not, now they're all overturned, and now the view of the courts in entire India, in the entire nation, is that reasoned orders should be passed. Even when the statute is silent, you should hear and pass orders. That is a requirement of law, because rules of natural justice require that the party should be heard. Because so far as rural folks are concerned, rural people are concerned, Tahsildar may be the final court. It's a revenue tribunal. We call it, colloquially, we call it as revenue tribunal. Assistant commissioner may be final tribunal. Deputy commissioner may be final tribunal, having regard to the poverty of the nation. Therefore, friends, merely because the person is poor, he should not be denied justice. Justice should be done with appropriate, application of mind. Even the Halsbury law of England brings out a jural position of such quasi-judicial bodies clearly. Many bodies are not courts, although they have to decide questions, and in doing so have to act judicially in the sense that the proceedings must be conducted in fairness and impartiality. This is the view of Halsbury's laws of England also. The characteristic attribute of the judicial act and decision, including the quasi-judicial act, is that it binds till it is set aside. Even if it is wrong, whether it's right or wrong, the order of the quasi-judicial body binds unless it is set aside or molded. The error of law or fact committed by the quasi-judicial body cannot in general be impeached otherwise than an appeal. Thus, I reiterate that the quasi-judicial authority, while acting in exercise of its statutory powers, must act fairly and must act with an open mind. Justice is rooted in the confidence of the citizen, and hence justice is the goal of quasi-judicial proceeding. If the functioning of the quasi-judicial authority has to inspire confidence in the mind of those subjected to its jurisdiction, such authority must act with utmost fairness. The principle that justice must not only be done, but it must be imminently appear to have been done, as well equally applicable to quasi-judicial proceedings, if such proceedings has to inspire confidence. Duty to assign reasons, even in the absence of any statutory provision, as a requirement of principles of natural justice, is judge-made law. Though many argue that such a stance must be left to the decision of the legislature, it has been the view of the courts that providing of reasons is implicit in every administrative action having civil consequences, such as a requirement of principles of natural justice. The litigant legitimately expects to be treated fairly. The Supreme Court in the case of Siemens Engineering, 1976, Part 2, SCC 981, has held that the rule requiring reasons to be recorded by quasi-judicial authorities in support of the orders passed by them must be held to be basic principles of justice. Justice Bhagwati held that this rule had to be observed in its proper spirit, and mere pretense of compliance with it would not satisfy the requirement of law. Since the order of quasi-judicial authority may be reviewed by the High Court in certain of the cases, if challenged, passing of reasoned order by the tribunal is absolutely necessary. The decisions of the administrative or quasi-judicial agencies are, if not accompanied by the reasons, will have the effect of whittling down the efficacy of the constitutional provisions such as Article 32, 136, 226 and 227 of the Constitution of India. In other words, since the orders passed by the quasi-judicial bodies on adjudication of disputes are reviewable or appealable, it is necessary for the authority to spell out its reasons for passing an order so as to enable the higher courts to know the mind of the quasi-judicial body while coming to the conclusion. The quasi-judicial authorities act like courts of the first instance in respect of the areas of law for which they have been constituted. It is not open for the litigant to directly approach the High Court in such fields. Now I summarize the reasons for emergence of quasi-judicial bodies. As a welfare state has grown up in the size and functions, more litigations are pending in courts, making it overburdened. It requires to have an alternative justice system. Approaching the court of law by engaging advocates has become very costly. With more scientific and economic development, the laws have become more complex, which demand more technical knowledge of the specific sectors. The conventional judiciary is suffering with procedural rigidity and delays justice. My suggestions to improve the tribunal, working of the tribunal, are as under. It should be manned by plural members rather than single individual. Now in Karnataka at least we have got the tribunals with plural members. And my view is they should be appointed by judicious process. Members should be both from technical background and legal one. Why I say that they should be appointed with judicial process means, otherwise the intention of creating tribunals will be lost. We find that, for example, about 15 days back, when this appointments to Central Administrative Tribunal, the members to Central Administrative Tribunals came before the Supreme Court, the judge who is in charge of such matters was interviewing the members. Only after satisfaction of the concerned judge, the members were, recommended by the Supreme Court to the concerned authorities. Such process should be adopted. Suppose if the working bureaucrats are appointed, there is no problem. The government will feel that such bureaucrats may be experts in the field. If the retired people are being appointed, then they should be appointed to judicious process. That's my view. And orders should be recent, and they should follow the natural justice, fair, and they should work as fair and impartial. Because I have got a different experience of my own. I'll tell you later after finishing my lecture. We find now that all the quasi-judicial bodies consist of plural members. Of them, one would be judicial member and one is the sitting judge or retired judge of this High Court with legal background. Now, so far as Karnataka Appellate Tribunal is concerned, Revenue Tribunal is there, Cooperative Tribunal is there, and Tax Tribunal is there. Apart from that, there are so many motor vehicles tribunals, this tribunal, that tribunal, there are so many tribunals are there. But these three tribunals are there, mainly under Karnataka Appellate Tribunal. And all are manned by plural members. One is judicial member and another is administrative member. And almost all administrative members are the working bureaucrats. I have already suggested to you that even while appointing a working bureaucrat, if he should, the government should send a person in such a manner that he should have a special knowledge about the subject. If the government does not appoint the bureaucrat, the working bureaucrat, who does not have knowledge in the field, then it becomes functus of unnecessary. It will be waste. Tribunal will be waste. And the members also feel that he is being punished. He is being punished by sending him to that tribunal. This is the feeling of the members. They may not tell this openly, but I am ventilating their grievances. If the person is to be satisfied elsewhere, the same position is not there, send him to tribunal. Whether he is qualified, in the sense qualified means he is qualified, I am not on that point. Qualified in the real sense. Generally, I find the grievance of the people is that the tribunal does not sit. This is my personal experience. My personal experience, see, I have already told I am from rural place. I have practiced right from Tahsildar to High Court as an advocate. Forget about the Tahsildar, Assistant Commissioner, Deputy Commissioner for the time being. So far as tribunals are concerned, our tribunals are situated in Bangalore in multi-storied building. For various reasons, maybe for good of the lawyers community, they start at 11:30. Working starts at 11:30. 11. In those days, it was 11:30. 11 o'clock or 11:30. Now, and the other benches were there at that point of time. Belgaum bench, Gulbarga bench, and one more was Mysore bench, something like that. So, the work of these benches will go for final hearing to those benches. Only for admissions and interim orders, they used to be taken before Bangalore bench. This principal bench, we can call it as principal bench. So admissions are to start at 11:30 in those days. Now it is 11 o'clock. 12 o'clock, the work closes. No hearing. And since I am from Belgaum zone, because my work was from that area. So I used to get some interim orders, come back and send the file directly to the concerned advocate who had sent me the brief. My work is over. And the members will go there. Members will go to Belgaum, Gulbarga, etc., etc. 2 days, 3 days sitting there, 3 days sitting there, 3 days to Mysore, and within that 3 days, the advocates will naturally took time, generally used to take time. 2-3 matters are being heard and 2-3 matters are being disposed of. This was the statistics. Consequently, they see the pendency now it is 60,000 or 65,000. I'm sorry to say, but let us have introspection. This is the thing. And the hearing matters were taken only with regard to Bangalore bench matters, that too in the afternoon. And the advocates were lucky and fortunate if the members used to sit on dot at 3 p.m. They would not come at 3. I'm not saying about this, the present day scenario in those days. I'm referring to those days because I practiced up to 1990 in tribunals. From 81 to 1990 I practiced, and thereafter I concentrated in different. So 3:30, 3:45, 4 o'clock. And within 15 minutes, 20 minutes, how can they hear? This is the working of. So all tribunals were almost partially working, temporarily working. Temporarily they were working. Therefore, friends, if such a situation is there, then how to improve the situation of tribunals? Not possible. Now we'll say that infrastructure should be there, new building will be there. It's all right. That is one part. That has to be done. We'll refer to that subsequently. But so far as working of so we are concerned. I am equating I and you are same. The judges are same. I am always saying wherever, in whichever conference I go, all judges are same. From Munsif to Supreme Court, judges are judges only. Only thing is jurisdictions differ. So far as quasi-judicial tribunal members are concerned, they are also judges. Virtually they are judges because they are deciding the fate of the people. Therefore, friends, we'll have to learn to sit and work. Sit and work. So far as courts are concerned, we sit meticulously by 11 o'clock up to 2 o'clock, then 3 o'clock to 5 o'clock, something like that. Let us have a fixed time. Let us not waste time. Now, the grievance of the tribunals would be, members of the tribunals is, stenographers are not available. This is a general allegation. That is a general requirement. Stenographers are not available. Same is the requirement in the civil courts also. Even in Supreme Court also, there are stenographers there are not good stenographers. So stenographer, see, actually it's a vanishing art. Stenography is a vanishing art. You can't expect now more stenographers henceforth. So stenographers are not there. Other things are being the normal. Now laptops are there, therefore the new generation has come and therefore they will have to start on their own. There is nothing can be done. And so far as tax tribunals are concerned, so far as Karnataka tax tribunal is concerned, one judge is a tax member, another judge is a district judge. I frankly say, I should say that district judges are not these experts in tax field. They may not know it. Therefore, the High Court should send such a members to such tribunals that the persons who have got knowledge about the tax. And even the administrative tribunal, the administrative members also should have the knowledge of tax. With this, I conclude. I wish you all the best. But I was a bit critical about the situation because since it is only an in-house interaction between the judges at large in the national level, therefore I wanted to be more critical. Let us discuss. You may scold me later after I leave. That is a different matter. But I wanted to put forth my ideas. I have putting forth my, and if there is any fault of mine, you can just correct it because whatever I have suggested is based on my earlier knowledge. Earlier the orders were only one paragraph orders. Nowadays I am finding, as a judge I found that the reasoned orders are there. reasoned orders are there. Most of the orders which are passed by Karnataka Appellate Tribunal on revenue side were said, though were interfered by a learned single judge, are upheld by the division bench. Are upheld by the, that means KAT orders are upheld by the division benches. So nowadays the situation have changed. Only thing is, since it is a national conference, I am appealing to you that we should rise to the occasion and do our best. All the best. Thank you. Jai Hind.